Hello and welcome at this last panel discussion of today. Very happy you are still here to dive into the interesting topic of both law and statistics and how they intersect, especially when it gets to fair AI. How do those disciplines relate to one another? I'm Juriaan Paris, working for NGO Algorithm Audit. It's a European knowledge platform for responsible AI, among other things, AI bias testing. We are very happy here to have a panel. I will introduce the panel first, then shed some light in the audit, and we dive into the panel discussion and wrap up with a Q&A with the audience as well. So hold your horses, there's some place for interaction at the end. First of all, I want to introduce the panelists one by one. First, we have Maribeth van Egmond. She currently works as a technology specialist at the Dutch DPA, the Autoriteit Persoonsgegevens, and worked previously as a cryptographer at the Netherlands Organizations for Applied Scientific Research, TNO. Next to her is, now the person behind is Carlos Mugan. He's currently a technology specialist at the AI Office of the European Commission. And previously, he was a Marie Curie Fellow and holds a PhD in post-deployment monitoring of machine learning. Good to note that Maribeth and Carlos are both participating in their personal capacity in this panel discussion, and their views shared are solely their own and not the institution they are affiliated with. Brent Mittelstad is a professor of data ethics and policy at the Oxford Internet Institute at Oxford University. And last but not least, Ilja Remitz. She works as a head of projects at NGO Algorithm Audit and worked previously in responsible AI as a corporate consultant. Good. What is an audit and how does it look like in practice? I will give a little bit of background about the research we did as an NGO on behalf and in collaboration with a big Dutch public sector organization, the Executive Agency for Education. And I have a couple of slides to walk through with you, and then we will start with the panel discussion. So first of all, some background. In June 23, there was a news article claiming that 79.6% of the appeals in a procedure against the decision of the Dutch government, the education agency, people have a migration background. There was a claim in a news article. Then there was like a political action following that the minister suspends the risk profiling algorithm and examines and announces an external investigation by PwC. At the same time, the organization itself asked as well, hey, what have we been doing and how can we learn from it? An internal investigation where we played a role and a part for the data analysis. And the focus of this internal audit we did was both qualitative and quantitative. Qualitative from the perspective of documentation and interviews with the people working on this profiling algorithm, and quantitative, a data analysis with a special emphasis on population statistics, which we will talk about today. So, what was the overall process in a nutshell? We start with the total population of students living away from their parents, approximately in 2014, 248,000 people. All those people get assigned a risk score based on a risk profile, the algorithm. And differentiation was made on the basis of three characteristics: type of education, age, and distance to parents, with a risk score as a result, with high risk being defined between 60 and 180. Next, it's divided per region, a logistic step, who is actually going to visit a student, that depends on the region. Step 3, desk research, a human in the loop, assessing this high-risk group identified by the algorithm, and makes a decision whether a student is actually visited at its house or not. Then a decision was made, unduly grants were allocated, and a decision was made whether there should be a repayment or not. Then the appeal procedure starts, and in this very last step, step 6, there was the claim about the 79.6%. How to measure whether it's correct or not, that was kind of our task, reject or accept this number. So, indirect discrimination occurred in this control process, yes or no? Some key takeaways as a background for this panel discussion from EU non-discrimination law. Is it direct or indirect discrimination? It is. we argue indirect discrimination, because based on these three profiling characteristics, there's no direct linkage between protected grounds, but can be a proxy. Then how can this be objectively justified as law requires? That's kind of an equation. It's not mathematics, but it's law. The objective justification is a legitimate aim, which was the case. There was a legal starting point. It should be a suitable method, a necessary method, and it should be subsidiary and proportional. And then our kind of contribution to this research, how can population statistics now play a role in this objectification test? And there we as well refer to section 6.1 in the Handbook of EU Non-Discrimination Law, where this is described, how indirect discrimination can be investigated using statistics. For this research, population statistics were provided in aggregate by the National Office of Statistics. It could be as well the case that internally there's data already available. These aggregation statistics were made available by the National Office of Statistics, and they have secure protocols in place to share these statistics in a privacy-preserving manner. What are the outcomes and the results? The 6 steps we just saw, we see here like the start division of the population at the very left-hand side. So this distribution of students with a non-European migration background and students with Dutch origin per step of this process. And we measured for 248,650 students. At the y-axis, you see the division between the blue bar, non-European migration background and Dutch origin, the start ratios. Like 22% has a non-European migration background of those 248,000. Then, next step, there is already a jump when applying the algorithm based on the 3 criteria. You see a jump to 36% non-European migration background and about 60% of Dutch origin. This only relates to 42,800 people at the very top, because this is the size of the high-risk group. How is it possible? Due to the proxy nature of these 3 characteristics. How does it look like? We can measure it. This is the proxy dimension and nature of education as a profiling characteristic. In this lowest vocational training type of education at the very left-hand side, we see a huge overrepresentation of students with a non-European migration background. By assigning those group a higher risk score, it indirectly affects this specific group. And you see an underrepresentation at WO, which is university training. So there is a proxy nature in this. We can do the same for the age category, where you see an inverse effect, the other way around. While in the logic of the risk profile, a higher risk was assigned to younger people, here we see there's an overrepresentation of students with non-European migration background in the elder categories. So the point is we can measure this, and we did it, and we can have then a discussion together how that fits in this legal framework. This is the proxy nature for distance. Okay, take that with you in this discussion. And we see as the next step in the manual selection, this is the human in the loop, that there's another jump in the overrepresentation of students with a non-European migration background. Only 3,180 are selected by humans for a control. And in this group, 63.2% has a non-European migration background. So you see, algorithm plus human step is a change in composition of the group. And this continues, and we can decompose it for all steps in the process, where it ends up to be 88.9% in this appeal procedure, which kind of comes close to the 97.6% which was claimed in media. So, what is this all about, and what has the political reaction been? Apologies to the disadvantaged students by the Dutch state, announced by the Minister of Education, a compensation to more than 10,000 students, especially with a non-European migration background, and the compensation costs are over 61 million euros. There has been like debate in Dutch Parliament how this can be prevented in the future, and it has been cited in court rulings. And then the takeaway is that based on those qualitative insights, controlling state actors could really take a normative stance in responsible AI. So how, then the question will be, for the panelists, can those quantitative dimensions inform the legal framework of responsible AI, and how can it be mutually beneficent? All data and source code is available on GitHub, so please take a look. And that will be the starting point for this panel discussion, where we have a first question to Brent Middelstedt. As a professor and seeing this field developing for a while already, I wanted to ask a question to you. To what extent do you think that states collecting these type of data, such as migration background, is it a good idea, or how should we reflect on that?
So we're starting with a very easy question, let's say. No, it's a complex one. It's one that has been at the center of the field, and by the field I mean work around fairness, accountability, transparency, and machine learning and AI, which you started to really see it take off around 2013, 2014, but that question has always been there of, how can you actually measure inequality, bias, unless you have access to sensitive attribute data. And I think in a very lawyerly fashion, it depends. There's not a blanket answer to this about whether the state should or should not be collecting this sort of data. We have to remember that there are very good reasons, sort of very core legal foundations, why we have data minimization, why we have data protection at all. These are very, there's a very long history to this, going back to, at the very least, the Holocaust, the usage of sort of public records to identify people with religious beliefs or certain ethnicities for targeting. But even much more recently, we're still seeing problems of essentially data that is collected for one purpose being reused in a way that is very harmful. We see in the UK, the NHS partnering with companies like Palantir, despite promises to patients not to share their records with those sorts of companies. The US 23andMe going under, suddenly lots of customer DNA data is up for sale to be used for who knows what. That's to say nothing of sort of the weaponization of country of origin, visa status, refugee status in the US by the Trump administration, period, and fertility trackers, how those can be used to track pregnancies, miscarriages, abortions, that sort of thing. So there's very good reasons why we would default on the side of data minimization, only collecting things that are absolutely essential. So I think we have a good reason to collect it in the sense that we know AI systems are biased. We know that they can cause discrimination. I think probably the healthy attitude to adopt towards it is you should assume that any sort of machine learning model trained on data about people, any AI system that is trained on data about people or being used to do something with or about people is biased. We don't know exactly how it is biased. We can test for that. We can uncover those biases. But in as much as they're being trained on data from the world, and the world is a biased place, we have to assume these systems are biased to begin with. So this isn't the sort of problem that you can just sort of close your eyes and say, well, we don't know, we haven't looked, we don't know what bias is there, so there's probably no bias. So the question to me, I think, really becomes, in what cases is it actually justified to collect it? Who are the sort of correct parties to either control the data, collect the data, have access to the data, and for what purposes? There, I think we can take some inspiration from the biobank model in medical research, in the sense of ideally you would want these sorts of tests to be carried out by a sort of disinterested but trusted third party, as opposed to companies themselves. But I think if we can reframe the question in the way that I suggested, where we're going to assume that systems are biased to begin with, then we can start to ask questions about, we shouldn't assume that the AI system is justified to be used in the first place. Rather, we have to provide a justification for why AI is necessary for a given purpose, where we know bias exists. And then we can start to go from there and say, okay, what sort of testing do we want carried out in the first place? What sort of both pre-market testing and sort of production testing or monitoring do we actually need to have in place in order to know that we are using the system in a sort of responsible way, a way that is actually transparent to the public? So that's kind of an unsatisfactory answer in the sense of I'm saying that I think we need to be asking a different question to start off with. But I don't think you can have sort of a blanket answer to that question of whether states should, by default, just be collecting this data. I think we have to explore these other pathways first of pre-market testing, of sort of justification in the procurement process, before we can even approach the sort of, let's have a blanket answer to that question.
Thank you so much for reflecting on that. And that brings me to a next question for Ilya Remitz. As well as a practitioner in this field, like how do you reflect, especially in relation to this audit I just introduced shortly, how do you reflect on using demographic data for assessing equal treatment, especially of those algorithmic supported decision-making systems, given that we live in this biased world, as one of the things Brent highlighted?
Yeah, so I think I fully agree with Brent, and I see the downsides of collecting this data. I see the risk of collecting and using this data for any purpose. A professor from the Netherlands, Frederik Zuiderveen-Borgesius, has said in an interesting meeting before, he said, any data that's collected for a specific purpose will be used for another purpose, even if we take this biobank model. In the Netherlands, the model that we used for this research did use this kind of biobank model because we have this independent Bureau of Statistics that provided us only with aggregation statistics. So we only got one number for a specific group. So we did not get the data on migration background to process for ourselves. And what I think how it really helped is that numbers get organizations to move. What we saw in this case was official apologies by the Dutch government and financial compensation for those who were involved, which is still a meager compensation if it was really you, but it's the best outcome scenario we can hope for. And one of the reasons this happened was because the numbers really showed that we have only 20% of students have a migration background, but the people who got these house visits were over 60% people with a migration background. So we really showed the unequal treatment, and that moved the organization and the Dutch government to do something about it. Amnesty in the Netherlands called for a complete stop of risk profiling by Dutch government. With an asterisk, they said, unless Dutch government can show that it's not discriminatory. And we think that the only way you can have this discussion if you can show that it's not discriminatory. Because if you leave this open to a discussion on ethics, organizations will always say, yeah, we discussed it in a group with diverse stakeholders, and we really evaluated it, and we think we're good. On official questions by members of parliament in the Netherlands, if a specific algorithm could be discriminatory, not this one, another one, the response by the responsible minister was, a DPIA was done, so we don't think that there's a risk of discrimination. And even if employees are really well-willing, we are a bit of a strange NGO in the sense that we try to work with the system, so we really work with organizations to try and improve things. And when we speak to employees, they really want to improve this, but they are responsible for a smooth process, they are responsible for general governance, they are responsible for privacy, and then fundamental rights get tacked onto that. If you cannot really make it clear how they should evaluate discrimination, they will prioritize other things that are clearer to them what they have to do. This is not that they're not willing, it's because they have this long list of things that are their problem. So we can make it their priority by giving them a very easy statistic to work with that very clearly shows unequal treatment, and then then their organization has to act on that. I've worked in commercial consulting before, where I've seen what happens when you don't quantify things. I was one of the auditors for the DSA at a big four firm, and one of the topics there is a systemic risk assessment, which also touches on fundamental rights like discrimination. And you can see that how these big tech companies describe it is very procedural. Like I said, we looked at it with a diverse group, and we think the risk is managed. We don't need additional mitigating measures. And that's why we really think these numbers really support moving into action. And we were lucky that we could do this through the Bureau of Statistics while preserving the privacy of Dutch citizens. I'll keep it at that for now.
Thank you so much. And from more the practical view and the boots in the ground in the numbers, we will do a little bit of zooming out towards the role and challenges you are facing when working for DPA, a data protection authority. And can you elaborate a little bit more on that? Like, what challenges do you encounter to do a meaningful audit? What access do you want to have, Maribeth?
Yes, thank you. Thank you, Ilya, for your. I totally agree with your words, and I think also for us as a Dutch DPA, fairness is a very important topic, and we are thinking a lot and researching a lot about how we go about that topic. And I think to shed some light on our challenges, it's good to realize that the way of supervision is a very broad spectrum for us. So on the one hand, we have on-site inspections where we actually go to a place to check if everything is all right. And on the other side of the spectrum, we have a more systemic overview of how companies are, how the state of companies is in the Netherlands in different sectors. So if we look at this on-site inspection, well, I work at the DPA only for 6 months now, but I imagine that in the past this would be easy as a technologist, and you would just go there and see what data they have and see if they if that is lawful or not, and then you check if it's correct or not, which is not as simple, but I think it becomes at the moment more and more complicated using algorithms and AI to do these on-site inspections. And one of the reasons why this is complicated is also because companies don't have oversight themselves. So we conducted a research last year where we asked companies about their algorithm use, and actually more than half of companies said they didn't even know if they have algorithms that use personal data in their company. So there is a lack of oversight, you could say, in a lot of companies in the Netherlands. Plus, a lot of companies say themselves that they don't have their risk assessment in place for the use of those algorithms. And a lot of those algorithms are also bought from an external party. So these three things make it very hard also for us to do such an on-site inspection because, well, if you go to this place and they say, well, we don't even know what algorithms we use, we bought them, and we don't have risk assessment, then it's also a lot of work for us to do these kind of fairness assessments. So I think that's already a large challenge for us. And even if they would have this fairness assessment in place, I think it's still a hard question what is right or wrong. And I know that there's a lot of frameworks in academics, but I think there's no clear answer to when it's what is right or wrong. I mean, this duo case, I think you could say, is clearly something is going wrong. But I think there's also a lot of edge cases where it's much harder to determine if it's right or wrong. And I think regarding the more systemic overview over the Netherlands, I would say that it's also very important, although I agree with Ilya that people could lie or make things more beautiful than they are. I think for us it's important as a supervisory authority to see, to have contact with people in organizations and companies that are responsible for the fairness, just as we have at the moment. There's data protection officers, and a part of our organization has a lot of contact with data protection officers about how things are going. Just because we don't have the capacity to go by every company and check their data protection, I think the same holds for fairness, where we need some kind of system where we can keep contact with persons that are responsible for fairness in different places. And then, of course, these people actually need to be responsible for the fairness in these organizations. And that's a challenge, I think, to have this balance between people that want to make it more beautiful. And then I think clear statistical measures or statistical metrics are needed. And for that, I think, well, it's good to collaborate with all of you on that topic as well. Yeah.
Thanks so much for sharing this more Dutch DPA perspective. More to the European sphere, I was wondering, to Carlos, a question for you is how to reflect on this often like stated criteria of the strictly necessity of processing sensitive data attributes for conducting these type of bias testing. Can you shed some light in that?
Yes, so many thanks. So actually you had a slide at the beginning that was showing this. So strictly necessary is a common term using law. And there is like the European Court of Justice follows this 3 steps procedure. One is appropriateness, second necessity, and then proportionality in the narrow sense. The first one, appropriateness, is the measure that we are doing. I'm gonna dive here statistically. So is the metric that we are using adequate for what we want to, for the legal aim? Second is necessity. Is there an easier way to get it? The classical example that people have is the classical of the fly and the bazooka. Okay, so is a bazooka appropriate to kill a fly? It's like, yeah. But this is necessary. And you will say, no, you can achieve it in an easier way. So looking at these 2 criteria, let's go now for this case. So appropriate. So which metrics are we using here? We're using like a version of demographic parity, which is we look at the average of different groups. For example, you have the Dutch, non-European, and you look at how the average has changed, okay? And what's the difference? This has like some problems. For example, one is the Simpson's paradox in statistics, is that it might cancel some of the effects. Let me give you an example. So if we look at salary of female and male, for example, it could be that the salary of female and male is the same, but for different reasons. For example, female actually have a lower salary, but then there is like affirmative action or a correction that overcompensates. If with this metric, we won't be able to measure this kind of discrepancy in how we get to the result. So I actually have this question that perhaps someone can take later, is that what are the requirements to measure equal treatment? So we were talking about equal treatment, so what are the formal requirements that we have from statistics to measure this metric, this notion that has been very discussed in distributive justice and moral philosophy? So what do we need to really measure this? Okay, and then I'm gonna move to necessity. So to evaluate necessity, there are several dimensions that we can talk about the data, right? So the amount of retention period, is it anonymized data, pseudo-anonymized, the amount of data, and technique that is often discussed is, can we predict the protected attribute? Okay, so for example, that will be, we select only, instead of having all your data, we select only a few of you, and then we'll have an algorithm that is able to predict the rest of the gender, let's say. So that could be an option, but I am unsure if this actually will be a less intrusive alternative to collecting your data. Okay, so we have appropriateness, we have necessity. This is how I'm framing it here. And then when I go to this technical solution presented, I think what you do is an unsupervised learning technique, which is a fair method to use. It could be. But I'm failing to see here which are other methods, what are the benefits in other metrics, on other algorithms, this like analysis in order to really dive on what is strictly necessary on processing sensitive data for bias detection and monitoring. So this is like an analysis that I think is super relevant to do to know what is the best method or what is the best approach in this situation. Unfortunately, this approach of proportionality is not, we cannot do it in a general way. It needs to be assessed in a case by case. So this is a strong limitation that there is in this approach, but I think it's a super good method that you have guys done, and we'd love to know more on how you also guys reflect on necessity here. Thank you.
Thanks for reflecting on that. Somebody who wants to react, you have like shed all your light on from different views. Somebody want to react first on interesting things heard to be said.
Yep. So I'll start from what Carlos was just talking about, actually. So this question of what different metrics and methods for bias testing are useful for, what they catch, what they ignore, basically what it is they're able to capture exactly, is incredibly relevant. It's something that I've only seen in the field really start to, in the sense of like connecting it to legal foundations or foundations in philosophy, political philosophy, for example. Only really started to see that be taken seriously last 3 years, let's say, roughly. I'm sure I'm missing some relevant work. But it's an incredibly important question, because when it comes down to deciding which sort of methods or metrics you're going to use for testing, how you're going to develop a protocol from them, those should ideally be informed by exactly those sorts of considerations. Like, you should have an idea of what it is that you're trying to look for, what the problem is that you're actually trying to fix. So some of the work that I know was mentioned in your audit report, where we talked about conditional demographic disparity, it was myself, Sandra Wachter, and Chris Russell did some research on that. We started to do that. We started to connect things with the legal foundations of non-discrimination law, showed sort of how different sort of bias metrics line up in terms of European non-discrimination law, US non-discrimination law, or basically whether you're trying to do formal equality or substantive equality. But I think it goes beyond that too. Another sort of formulation that we proposed since then in the context of leveling down is that what you should actually be looking at when you're choosing the metrics that you want to use is what harms are you interested in. So what is the specific type of harm that you're trying to avoid that your system is causing. Really simple example of that would be if you have, say, a cancer diagnosis system or a risk classification system for cancer. Are you more concerned about, say, incorrectly identifying somebody as having cancer when they don't have cancer? So are you more concerned about false positives or false negatives? Presumably, you'd be more worried about missing cases of cancer than you would about false positives, but there are plenty of considerations there. So in that piece of work we went through, and we actually looked at a bunch of the most popular bias metrics and sort of categorized them in terms of the types of harms that they're actually looking at. But I think in general, I think this is kind of going to your point there, where I think by viewing the metrics in a different way than just what they're strictly measuring, like finding ways to put them into a framework based on their utility, like the sorts of harms that they're targeting, I think is maybe a way to start to address the type of question that Carlos was talking about there.
So
I want to add one small remark on that, is that the Dutch equality body, College voor de Rechten van de Mens, has now put out a evaluation framework specifically for risk profiling algorithms, so specifically for the case we were discussing. And they've said that the relevant metric for equality in that context is selection rate, so who gets selected for a review. And that's also one of the main reasons why we chose this metric in this case, because we try to follow what such an influential agency puts out as the relevant metric. But I agree with you that there's lots of other metrics to choose from. But sometimes I feel like this discussion on, it's unclear which metric to choose, also stops people from actually doing the analysis. So I'd rather take an imperfect metric to still measure. Sorry for.
okay. So I like this metric, this approach that Brent has presented. I think it's quite practical, but also it's a bit of consequentialist. We look at the results, right? I think that it misses a bit of the ontological of what do we want from the algorithm to be. And this is this trade-off, right? So actually my question is, what are the requirements, really, if you think it statistically, that need to be met in order for a metric to be satisfactory in this particular case? Like, this is like a lot of effort, and I think that they sometimes propose the metric without knowing if it meets really formally the requirements. So I think there's an effort that we often need to do that is missing, is what are those requirements, and collecting the requirements from the application, one by one in a very methodological way. An issue is like, yes, there's many metrics, and often we talk and we argue and we get in this rabbit hole and we don't know how to decide, how to measure, how to select. Yes, we have to select an imperfect one. But it's often also, we need to be aware that we cannot achieve all fairness metrics at the same time, and some of them are irreconcilable. So achieving one will probably lead to not achieving one. That's why I think it's so important to have clear criteria on what a metric should measure.
But then that brings to my mind, it is kind of codified in law already. What is then a better or less good fairness metric? We can kind of take a decision on that, as we did, for instance, in this study. Can't we say then at the same time, hey, this challenge about proxies and correlations, how it intersects, isn't there just a sound methodological answer for that by using these type of population statistics? And shouldn't we then just cut the Gordian knot? Oh, we can discuss from a qualitative perspective, it is in a less or certain extent indeed proxy nature, or should we just solve it by computing those statistics?
Yeah, I think that that there are ways to put everything in statistics, but on the other hand, as I imagine as a DPA going somewhere and then just checking boxes about statistics, one will be a bad incentive for presenting things in a way that it checks the boxes on statistics, because it might be that there's more under the statistics happening than only the numbers. Also because there's many different type of features that could be harmful, like you just said. You also need to determine which harmful features you have in an algorithm. So the determination for what you're going to put that statistics on is also a choice. So you might be still, if you would only go there to check the boxes for the statistics, I think there would be things that you might miss. But I'm very curious what my fellow panelists think about it.
I don't know if the audience know what's proxy discrimination, actually. So, yes?
Hence, for somebody who wants an explanation on proxy discrimination by Carlos, we can take some time for that. Carlos, can you help us introducing the
Sorry. So I think that I often hear this a lot. It's like when we took a decision for something, that's again gender, sorry for this, but like if we don't look at if it's a male or a female, then the decision is fair, right? But the reality is that there are a lot of features that correlate with gender. So even if we do select gender, this is known as equal treatment as blindness, and is translated in machine learning as fairness through an awareness, okay? So many features correlate with the protected attribute, with gender. We already know this. So if I have to hire someone for some reason, you will see that it correlates. So for complex algorithms, it's very easy to detect all these features, all these correlations, okay? So proxy discrimination relates to what are all the rest of the features that correlate with the protected attribute, that even if you remove the protected attribute, discrimination keeps happening. Do we agree here?
Thank you so much for that explanation. And one of the questions then emerged, we can quantify correlations, we can quantify population statistics. We see those beautiful red lines kind of as an extrapolation in those proxy natures. That's where we can get. How do we then assess those red lines? And does it result in the battle of numbers that we say, oh, but in this algorithm there was this steep red line, but there in that algorithm you have a less steep line and that's deemed okay and this wasn't. The feared battle of numbers, how do you reflect on that as a legal expert among those mathematicians and computer scientists, Brent?
So yeah, it can definitely happen, a battle of and I would say we have to clarify, where are we talking about the battle of numbers happening? Is this in a courtroom, because there's a very sort of specific set of answers in case law that deal with that, about how you can submit or when you can submit statistical evidence in a case of non-discrimination. But equally, the battle of numbers could play out in the media, it could play out within a company, it could play out in lots of different contexts, and I think it will be different in each of those. So one thing I wanted to say about the battle of numbers is that even if it does play out, it's almost presuming that there is some sort of political will or interest in solving the problem that the numbers refer to. It's just implied by the idea that you're battling about the statistics. And that's not always going to be the case. This ties in with the original question around the availability of data, collecting sensitive data. You can have all the evidence you want. You can have evidence that disagrees with each other, red lines that disagree with each other. We have lots of areas of discrimination or inequality where we have really good evidence for it for decades now, and yet it's not something that is fixed because the political will does not exist to either fix it in a holistic way or just the solutions that have been tried thus far haven't worked particularly well. Gender pay gap is a great one. That has been reducing over time in many contexts, many countries, but at the same time, you need the political will. You can have it very well documented, but you need the political will to actually do something about it both in the short term and in the long term. I think one potential way around having a battle of numbers play out would be through sort of very top-down standardization around bias testing. We may or may not get that. I'm not saying that's necessarily a good or bad thing because the standards don't exist yet, so it would be too early to say that. But at the very least, you could, through technical standardization, the sort of stuff being carried out by CEN and CENELEC as part of the AI Act, you could arrive at, here is a battery of tests, here's a bunch of metrics, methods that you should use if you're carrying out bias testing, either in general or, say, in a particular sector. So that is one way to sort of avoid the battle of numbers, or at least to constrain it in some way, because of course you may still have people arguing over, this is the right metric versus this is the right metric. But I think that is just kind of making the problem temporarily go away, because I don't think through those standards you're actually going to get what a lot of people are ultimately looking for, which is essentially somebody to say, here's the threshold for when your system is biased or not biased, or here is a very clear sort of quantitative measure that you can use, something like the 4/5 rule, in order to say that your system is not biased. I've seen the standardization process that's happening with CEN and CENELEC and the discussions around the bias standards, and I was sort of shocked to find how often the 4/5 rule was being floated as a serious threshold to include. For many reasons, which I won't go into, but just anything that is sort of easily quantifiable is necessarily going to be attractive because it seems to solve the problem. So that's sort of playing around with this idea of the battle of numbers. I think there's also a question of whether bias testing in there can still be very useful for purposes of democratic oversight. And I think even if you do ultimately result in people arguing over which the correct red lines are, which the correct metrics are to use, I think if you can have that sort of conversation in the context that I was talking about before, where rather than focusing on the statistical metrics, you're saying, you're arguing about harms, you're arguing about values, you're arguing about the things that you want your system to do or uphold in this sort of deontological way that Carlos was mentioning. I think if you can have it on those terms where it is very much within the sort of conversation you would expect to play out in a political domain in any case, then I think you can kind of push past the battle of numbers, or at least push it into a healthier place where you don't have to have a degree in mathematics in order to engage in it. Because I think that's ultimately what we're trying to get to, is to not have this sort of barrier to entry to that conversation.
Thanks. And maybe that's a great cue to link this study and audit, which we might see more often with the AI Act coming into force, back to this big European regulation over 5 years ago kind of introduced, the Digital Services Act, where there's this audit provision as well in Article 37, independent third-party auditing. And Ilya, you shed some light on that you were part of that and have some critique, like how that falls out in practice with this systemic risk assessment. Can you elaborate a bit more on that? What would it be beneficial, and should it fill in this void that Brent describes to be there more numerical and quantify more, for instance, about recommender systems, how they work, how they function, what should be reported, rather than this qualitative judgment of compliance check?
Yeah, so I think they should go hand in hand, and I fully agree with Brent that in the end you want to talk about how systems impact people. Because in the end, the AI Act, but also the DSA reflect on fundamental rights, the fundamental right of equality, a fundamental right of privacy. In the case of the Dutch scandals, social security. So that's the core question, but to have that discussion in a meaningful way, quantification can help. And this, I basically said this before, like if you look at the systemic risk assessment, how they are output now for the DSA, they're so high level that there's no meaningful discussion of impact on human rights, and their quantification really helps. And what I think is interesting that the DSA actually already calls for this quantification, but it's not yet present in the systemic risk assessment. And that's why also we as an NGO, maybe it's a bit cynical, but we really push for this quantification. Although we see sometimes the downsides, it's because if you don't quantify things, it leaves this room to just be this high-level, floaty discussion. We've seen it at the DSA, even though there is a request for quantification, and I think we as a community should request this for the AI Act, but also broader. We should keep on asking this. Today there was maybe a few days ago, there was a report by a Dutch court of audit about another Dutch social security agency, and this court of audit gave green check marks on bias testing, but in their report it says there was no evaluation of indirect discrimination. And there you can see that if we don't quantify it, this organization still got green check marks. Dutch government is now saying, hey, we got green check marks, we're all good. And that's why we keep pushing for this quantification, even though we see the downsides.
Thank you so much.
But I wanted to react. Couldn't it be, I think the obvious conclusion is that we need both, right? We need both the numbers and the more holistic view, because I think what you just said about the check marks could also happen the other way around. Like you have maybe 3 green boxes for some fairness metrics, and you say we're all good, without having thought behind that and having thought a little bit more through. So I think for both sides, it can be, you can make it more beautiful than it actually is.
And that's a very interesting remark, because what I think might be happening is that organizations will be using debiasing methods to correct the metric that they're using. So they're manipulating the data and their algorithm to make sure that, for example, male and female are equally treated by the algorithm. But as we've seen in the results, where we also put data on the human process, is that there's a lot of bias involved, and there's a lot of discrimination, indirect or direct, in the human evaluation steps. So even if they can show our algorithms are fair or not biased or are not discriminatory, whatever words they put to that, then this doesn't demolish a system of inequality. So absolutely, it cannot be just the number and the tick marks, but we hope that we can at least start there and then move towards more holistic approach. Yeah.
Any reflections? Otherwise, I wanted to shed some light in this last point Ilya raised about the human in the loop. It's often put forward as a solution to prevent bias in algorithms and AI systems, but as we saw, there's a huge jump as well there, which can partly be explained through duplication of the profiling criteria in both the work instructions for humans and in the algorithm. But still, we know humans are not bias-free at all. So working in this symbiosis from both quantification and qualitative judgment according to the doctrine of law and ethics, how do we then end up with this symbiosis as well between human-machine interaction that we do have on a meaningful way oversight of AI systems?
So, okay. like to comment on how I like more the AI Act than the DSA, but I shouldn't do this, okay? But anyway, so I think that the issue with there's two things, right? Humans and computers, right? Often humans are much worse than computers, but the issue for me is the scale. So while as a bad human with a bad behavior myself, I could harm certain people, say a bad police officer can do certain harm. The issue here is the automation and the scale. So algorithms often have like very large scale. So even if it's better than the human, the issue is like we have the scale will impact millions. That's why it's so important this algorithmic discrimination. And even if it's often bad in the human, I think there's these two things that need to be evaluated and oversighted here.
And what role then evaluation and monitoring plays in that role, and how then should these metrics be quantified? So just one way how it comes together, quantitative metrics and then a qualitative judgment. Do we see any bright examples you think as an example that should be put forward as a best practice?
I don't have a bright example, but I do think studies like this show the bias also in the human process, and we're having this discussion now, at least in the Netherlands, which started at unfair algorithms, which also include now unfair governmental procedures. And so to do data analysis on a human process can also help get this discussion going, because you can do the same analysis. You can compute fairness metrics on human processes, and we did. And that's helpful, because this same organization is now trying to structurally revise their work instructions as well. So this data analysis can also be a shining light example for how to improve human processes. But I don't think that's happening very much in practice yet.
Not yet, and maybe it takes time. It's early development, this digitalization, especially on the scale of history, and we have to bite through the sour part of the apple, and then ultimately we will get everything sorted, hopefully, from an optimistic perspective. It's time for questions as well from the room and the audience. I see many hands. Not sure whether there's an extra mic in the room. I think it is. Maybe let's start here first with the second row.
Thank you for this great panel. I'm David from the Fundamental Rights Agency. When I hear like battle of numbers, that's like music to my ears, because I also think that, as you said rightly, I mean, something is going on, right? I mean, there is looked into, and also when we think back, like, I always have to think about smoking causing cancer. That was quite a battle of numbers, right? And there were quite highly esteemed statisticians in courts telling that, oh yeah, causal relationships are quite hard to prove and things like that. So that's great, but I'm rather worried that there are sometimes issues in accessing data, actually, and I think that's also, especially on platforms, is an issue. So I'm quite curious to hear your take on, because like in the AI Act, we have an interesting provision, Article 10.5, which says that if strictly necessary, you can collect data on protected characteristics in order to prove discrimination, with a whole lot of safeguards included. But yeah, I wonder, what's your take on like where you see data protection sometimes in a way of doing this fairness testing, either by being abused or being misinterpreted? Because I think you can use it, of course, if it's needed. But yeah, I'm just curious to hear your take on that.
So I'll talk about that specific provision, also a related one for equality bodies and market surveillance authorities. But on your question of does data protection stand in the way of it, can it be sort of abused to prevent this sort of testing? I think yes, it absolutely can. But I don't think we should limit ourselves to bias testing is very easy to carry out if you have production data. So if you have data, let's say, about actual customers that are being analyzed by a system, the offers given to them or the outputs, classifications, whatever it is. That's kind of like the ideal of how you'd want to do, let's say, bias oversight. But you can still do a whole bunch of stuff before, or if you never have that sort of data. If you have access to a system, you can feed it test data that you've created yourself. Let's say you're a third-party auditor. Or if a company is, if they're under the AI Act, they should be carrying out performance testing themselves before they release it on the market if it's a high-risk system, in which case certain bodies like equality bodies, market surveillance authorities will have access to that documentation, also to the data sheets for the data that was used in that sort of testing. So I think there are some potential mechanisms by which you can, let's say, reduce that sort of access problem. But you could still even do testing just literally with synthetic data. Again, assuming that you have some sort of access to the system so you can actually carry out testing, see how it works with that non-production data. And while that won't tell you if discrimination has actually occurred to real people, it can give you a sense of where the system is potentially discriminatory, where it just performs badly, and you can already start to take corrective actions based on that. Some of the old corrective actions we would think of is you need to collect more data for the people that it's performing very badly with, but you could also say adjust artificially the how it's classifying cases. So for example, if we know a system is really, really inaccurate or performs really, really badly for a certain type of patient, we can say for those types of patients, we're actually going to boost the recall rate, and we're going to just artificially give them, let's say, more cancer diagnoses than we otherwise would have given them. And with that, you don't need to actually have the data for the patients that the system is treating. You just need to have some sort of data about cancer patients that would be relevant to where the system is being used. So yeah, I think there are potentially ways around that access problem, but we should be looking at, in much more detail, the rights and powers that market surveillance authorities and equality bodies or the national competent fundamental rights authorities will have, because there is a way within that, if the companies have either sort of defined the intended purpose of their systems in an extremely narrow way, or if they basically set out that our expected accuracy for certain groups of people is really, really low, and so actually the system is not biased or it's performing as intended. These are the sorts of things that an equality body could find out and flag and basically chase up and do more investigation of. Or if they see that the way that performance gaps have been calculated for certain groups are very sort of narrow or limited in some way, they can request further testing to be done through this market surveillance authority. So I think there's some promising avenues to kind of lift things up a bit.
I'd like to add a little bit to that. We do see also when we talk to Dutch governmental organizations that even if they have nationality data, for example, they are very hesitant to use this type of data to do bias testing. Or they outright state that they are not allowed to because of the GDPR. I'm not a privacy lawyer, but I know that there's a lot of privacy lawyers who disagree. They discuss more of that it's a discussion about rights and you have to weigh these things, but that there are possibilities to do it. There are also Dutch governmental organizations who already do this. They use their internal data that they have on nationality and background to do bias testing. So we see these diverging opinions between privacy lawyers, but we do see it used as a shield. We are not allowed to do it, so we will not do it. So what we try to do in the Netherlands is point them towards the CBS, and there's also another statistics organization in the Netherlands, the CPB, the Centraal Planbureau, or a planning agency, that has now set up a collaboration with our Bureau of Statistics to use the same data we did in an aggregated way, in this biobank sort of way, to be able to do this testing. Then there's also other ways we think you can do meaningful testing even if you don't have the data. First, if we look at this case we presented, DO could have known, this agency could have known. Why? Because they are using educational background. And if they really sat down and reasoned about this, in the Netherlands it's very well known that because we have educational levels, that the lowest vocational training has a major overrepresentation of people with a migration background. So, and this is actually what we call a proxy, but we don't need data to prove it's a proxy because it has been shown in social sciences that this is the case. So even by qualitatively evaluating the input data, they could have known that there's a large risk of proxies even without the testing. Then there's a last thing that they think they can do, is that there's methods in academia, for example, unsupervised bias testing, which we've developed a tool to do so, where you can use clustering methods to just show which groups you are treating differently from other groups. Then to evaluate this is still a qualitative exercise. You have to look at plots and discuss these plots. But if you can see that you're treating a specific group differently, you can reason about proxies, you can reason about the systems of inequality, even without knowing exactly to which group who belongs. So, elaborative answer.
Thanks so much. And without further hanging at this microphone, I would see another question, other hands back in the room. 1, 2, 3. First the lady over there, then in the middle.
Thank you. Thanks for a wonderful talk. It was really interesting. I'm a lawyer based in London. I just had a question about the references that were made, which I think were really apt to the potential for democratic oversight, political oversight, possibly also judicial oversight to these systems. The question I had was whether the existing processes for impact assessments, where we might see the auditing take place, do you think those processes have enough inbuilt transparency, so like the DPIA, the FRA, for those kinds of oversight, judicial and political, to be realized in practice? I'd be interested in your perspectives on that kind of the transparency of the outcomes of the audits.
Well, as far as I know, the DPIA doesn't have a risk assessment for fairness in algorithms, but I'm not a lawyer, but I think there are fairness assessments like IAMA that have more of a fundamental rights impact assessment, but it's not obligatory to do that kind of things, and that's also what comes out of that research that I mentioned that these risk assessments are not in place in many places. But then there's even a step before that companies are not even aware of the fact that somewhere in their company, or we can't say that they're not aware, but they say they have no idea if they have algorithms that use personal data in their company. So I think that would be a step before actually doing the risk assessment, to have an oversight of what is actually happening at your place.
Yeah, I can add to that. I guess the thing that always worries me with impact assessments is, one is the willingness and sort of capacity to do them effectively in the sort of way that was, just being described, where, say, the only type of discrimination that was checked for was direct discrimination. And I'm sure there's many reasons why that could be the case, but I always worry about sort of the gamification of those. Also the timing of them. If they're just sort of a once and done thing before the system ever goes on the market, you're gonna miss all sorts of biases that would emerge when it's actually being used. And as far as I know, DPIAs don't have to be made public, although I'm seeing shaking of the head. So good on that. And I have to admit, fundamental rights impact assessments, I don't fully know how public they need to be made. I believe that the market surveillance authorities, quality bodies, national fundamental rights authorities, that they can get access to those. To what extent they could then use those, like submit them in a court filing, for example, I'm not sure. But at the very least, there is some level of access there. But again, I'm always skeptical about impact assessments just because there's such variation in how they're actually carried out. And it is very, very easy to either just do them poorly or to do them extremely well, but to do them in such a way where they present the best possible version of your system to the world in the sort of classic fairness washing sense that we've seen over the years. So I'm skeptical, I think is the short answer.
we're more hopeful for the Article 10 requirements of the AI Act, where there's actually a requirement to investigate how bias influences fundamental rights, which is still a vague description. But this might be more helpful in this space than the fundamental rights impact assessment, in the sense that this actually has to be part of pre-market evaluation.
Thank you. Question here at the middle. Yeah. And then the young man here in the white shirt.
Hi, Midas Nouwens from the Dutch Data Protection Authority. I have a question about the practicality of some of this. So I think we've talked today about methods and theoretical opportunities to use statistics and other things to detect issues. I think from our point of view, often the problem is not that it's possible to use these methods, but that most organizations don't have the capacity to use any of this, right? So I was wondering if you have any ideas of how to increase either the analytic capacity of those organizations or to support them in some kind of way. Are you committing to doing more pro bono work, spreading your own capacity to these organizations? I'm just wondering how we can scale up this, right? Or are you saying, no, this type of work is only for public authorities or companies with a lot of resources? How do you see this spreading practically?
Maybe some words from my own experience with this duo research. It's when we got like knocking on the door of the National Office of Statistics, we first ended up at the wrong division. It was the methodology division. And they wanted us to help with the methodology of doing this bias research. And we were kind of some of the first public sector organizations, and we were assisting DUO, the education executive agency, we were kind of knocking on their door, and then we were redirected because we already had an idea what we wanted to do. It was kind of we were amazed that we were kind of the first, and we think there is possibilities to scale up. It's more an institutional problem why other public sector organizations in the last 20 years, when this was still possible, didn't act. So it makes it more institutional, whether there is also sometimes a stick rather than only the carrot, because many people don't know where the carrot is hanging at the moment.
And Brent has already said this. These are easy statistics. Like any organization which has anyone who can do data analytics can calculate the statistic that we showed on equal treatment. Like how many people are selected at a process step. That's a very, very simple procedure from a data analytics perspective. The hard part is getting the data, being allowed by your internal data privacy officers to use this data if it's internal, or to go to external parties who have this data. Getting the data is the hard part, then analyzing it's easy. And it's not, I don't think it's capacity building to get to the data. It's really a matter of data collection. And using methods that are already there. So for governments, they can already go to this Bureau of Statistics in the Netherlands, and I can imagine that other ways exist in other European countries similarly. Okay, it's not accessible to companies, but at least for governments, there's a step. So for me, it's not about analytics capacity, it's about data.
Just to amplify that point. So I think there's quite often a misconception about bias testing, which is you need to be an expert in machine learning or AI. You need to understand how the model works. You really have to have this detailed knowledge to do it. If you're trying to answer questions like, how do we fix this bias that occurred? Or why is this bias occurring? Then those are very difficult questions that absolutely require those skills. But if all you're trying to find out is in what way is the data that's being used biased or the labels biased, and have people been discriminated against, you're essentially just looking at the input and the output side of the system. So it falls very much in that camp of traditional data analytics. So the barrier to entry is much lower. And just to do a quick plug for a piece of work that I'm doing, algorithm audit, I think is going to be involved in too. I'm part of a Council of Europe project currently to develop an assessment protocol for equality bodies, specifically for bias testing. So it's exactly on this topic of how do you basically translate this stuff into something that's very usable for equality bodies that will have different sorts of expertise in data analytics. So that's ongoing, but it's something that will happen in the next over the next 18 months, I think.
Yeah, to add to that, I think I agree that it could be very simple to do data analytics and do simple bias testing, but then I think it's also a matter of culture in some company that someone raises the problem of, some simple data scientist could easily find bias, but then the step towards stopping that algorithm or drastically changing it is, I think, in practice very hard. So it's also, I think, matter of awareness for companies to that this could actually be a problem and maybe even illegal.
And the cultural willingness to do something when you find it. You're absolutely right there.
Thanks. First, a question here of the young man in the white shirt, and then a last question maybe at the back.
Thanks. My name is Niels Westerlaken. I was a former DPO, a data protection officer, at one of the ministries overseeing a major risk profiling algorithm. So I'm very curious, especially what Maribeth van Egmond thinks regarding this last point on culture and what is in the organization's interest to change or research or find out about any algorithms that might help them be more efficient or whatever the thing that they at that point are trying to achieve with the algorithm. In linking it to the case you guys presented, where does it go wrong for you, maybe the most? So is it at the end where there's the actual discrimination, where there's also might be a solution of debiasing the data, or is it earlier where the human in the loop is maybe also adding to the discrimination in the system? Or is it the automated profiling that's a big risk for you? Is it the algorithm itself with the AI Act also maybe giving more way for enforcement there? Or is it, from my data protection perspective, in using the metrics, the age, the education, those metrics for the reason that they're trying to find fraud in the system? Why are these data points, these personal data of the population used? That's something, as a lawyer, I know something about and can assess the necessity and the proportionality, but then it gets a numbers game, and for me that's really hard to assess, let alone win the battle of the numbers.
Yeah.
So what do you see as a supervisor happening there?
Well, just speaking for me personally, what I know about this Duo case is that where your question is, where does it go wrong? What I read about it, I just work at the DPA since half a year, so what I read about it, I think it goes wrong in the making already. So this algorithm was, and I think Ilya can maybe, or you can maybe add to that, was the way it was made was not very thought through, but it was more from a sort of experience in the past. We put some things together, it seems to work, let's go. I think that already has a very high risk of things going wrong. But on the other hand, if they would have done a very thorough data analysis, which took months and they thought it through a lot, then still you could have a very biased algorithm. I'm not saying that it's the case, but I think it just, in the making already, it was not the risks that it, just as Ilya said before, I think the risks were not taken into account. So I think that is the point where it, if you look at it historically, that it already went wrong there. But I'm curious to hear what you think.
I think you raise a point that I would like to really give back to the audience. Exactly the questions you ask, why this data, how do you know it's reliable? Why do we need this? Um, those are exactly the questions that need to be asked before any data scientist or any data analyst starts. So I would like to ask everybody who's not a data person in this room to please ask those questions, even if you feel like there is a distance between you and the analyst doing the work, because those are exactly the questions that need to be asked beforehand. So I think this is not related to your question, but it's really something really helpful that you raise, because this is your expertise and you can help building better algorithms by asking these questions and not being shy because you work in a different discipline and you have different expertise.
Thanks, and then it's time for the last question at the very end. One more time. The hand somewhere there. No. Somebody else? One last question? Yeah.
It's a bit, I think I'm a lawyer, so you may find this question a bit naive or stupid, but I see we are talking about the correlation and not about causation, right? All these models and algorithms based on correlation. And I want to know whether there is any feasible path for like causation algorithms based on causation and not correlation in order to make these decisions that it's based on fundamental rights and everything else. I mean, I don't see anyone talking about the possibility of using causation, because I know that it's harder, there are a lot of barriers, but I want to just understand if this could be a feasible path or not.
Want to quickly react on that? Thank you. For the other microphone. So I think first of all, causation has different meanings, and within the field of philosophy, and we work a lot with philosophers as well, they say it's impossible to prove it in any way, since Descartes, basically. So they say there's no causation at all. Then in the field of law, it is a very important concept, and that's where we kind of then brings the field of statistics from a philosophical perspective and more scientific philosophy as well, saying, hey, we have this lot of kind of noise in statistical modeling around machine learning and exploiting correlations, and correlations are an inherent element of statistical modeling by definition, because all like distributions are based on random variables, and all random variables except two dices who behave independently have correlations. So it exists, but we can kind of measure it using random sampling and hypothesis testing. And that's exactly not the statistical methodology that machine learning and AI is following. So that's what we kind of, in the different section of this audit report, it was not about population statistics, but about random samples and how random samples could be informative to reject or accept a certain hypothesis and do testing on it using like t-test, z-test, f-test, and there it gets like jargon again within. But that's very important, how these type of tests and methodological setups for testing algorithms as well pre-market, before they are in use, how that can be linked to those open legal norms, especially from non-discrimination law. For instance, is it appropriate, this profiling characteristic? That can be supported by quantitative evidence. It still then is a qualitative judgment if you want, and it is lawful to use it. So I think it has different meanings in different fields, and that's kind of the aim, to connect those with each other. That's my personal reflection. One last remark before we're gonna wrap up and join the drinks at this late hour.
Yeah. To give a concrete answer to your question, like proving causation has been a holy grail. That's why we have a scientific method that's used for medicine testing, for example, where we do very careful experiments with testing groups and control groups, so that we try to control for every other variation, so that there's only the medicine that's different, and then we have a good enough evidence that we can say, okay, we accept that there is a causational relationship between the medicine and the outcome. Usually, this is not realistic in any sense in the type of algorithms or machine learning that we talk about right now. It's possible to set up more careful experiments, and we support that. But people who talk about causation, especially when we're discussing big machine learning models, they're trying to find a holy grail that I think the whole of science outside of machine learning would be very happy if we can find a way to mathematically, reliably prove causation in another way than controlled experimentation. But there are modeling ways, there are many academics who work on this, but no.
Thanks. And a last remark by Brent, and then we wrap up.
Yeah, so this actually isn't going to be on that topic, but I just wanted to take the chance now to just congratulate Algorithm Audit on the audit that you performed, the report that you published, because I've been working in this field for longer than I care to admit, and the sort of thing you've done is, I think, the ideal that was always in the back of my mind about what AI accountability could look like, in the sense of somebody recognizes there's a problem, a careful analysis is carried out, and something actually happens as a result of it. And so it's really sort of, it makes me very optimistic to see that stuff like this can actually happen. So thank you for doing that.
Thank you so much. And thanks as well to the audience. Ilja Remits, Carlos Mugan, Brent Mittelstad, and Marie-Beth van Egmond.